Good afternoon and welcome to this afternoon's event, Towards a Theory of Federalism. I'm Praveen Fernandez, one of the directors of programs at the American Constitution Society for Law and Policy, otherwise known as ACS. For those of you who are not familiar with ACS, we are a national network of judges, lawyers, law students, and policymakers dedicated to ensuring that the law is seen and understood as a force for improving people's lives. ACS does this work, of course, by sponsoring and shaping discussions and debates that outline critical issues of law and policy. This event is the first in a series of 4 debates that are designed to identify common ground by exploring the fault lines in the progressive community on critical issues of law and policy. Today's topic will feature 2 scholars debating how we understand federalism. And in fact, they're going to explore intra-progressive tensions in how we understand federalism, the relationship between the federal government and local and state governments. Federalism has historically been, if not a bad word, then certainly code within the progressive community, conjuring up conservatives and conservatism. And I suppose that this association is not without reason, for during periods like the civil rights struggle in the 50s and 60s, states' rights were the purported rationale for opposition to landmark legislation. Additionally, this came up in other instances, such as the landmark federal legislation, the Violence Against Women Law. However, as many commentators have noted subsequently, a new brand of political actors, progressive lawyers, policymakers, and scholars have been invoking federalism in recent years to achieve progressive means, where the federal government has sort of stalled. Some have said that this is a return to an earlier understanding of federalism, such as during times like the late 19th and early 20th centuries, where state initiatives were the cornerstone of the progressive agenda. So, progressives have cheered developments on the state and local level in areas such as climate change and LGBT relationship recognition. In other areas, such as immigration, progressives have both decried draconian statutes at the state level, while cheering other initiatives at the state and local level. How are such tensions resolved? And going forward, can we identify a unified progressive theory of federalism? These are difficult questions, but fortunately for us, we have experts who are up to the task of answering those difficult questions. While our moderator will introduce our fine panelists, I have the pleasure of introducing our moderator, Elizabeth Wydra. Elizabeth Wydra is Chief Counsel for the Constitutional Accountability Center, a think tank, law firm, and action center at once. She frequently participates in Supreme Court litigation, for which she has been honored for her exemplary writing, and has argued numerous cases before the federal courts of appeal. Elizabeth joined CAC from the law firm of Quinn Emanuel Urquhart and Sullivan, where she worked with former Stanford Law School dean Kathleen Sullivan in the firm's Supreme Court and appellate practice. The truth is I could go on and on about Elizabeth, but I'm going to stop here because you have bio sheets in front of you. The truth is we're very lucky to have her here because few people cut through thorny issues with as much depthness. Elizabeth.
Thank you so much for the lovely introduction, and thank you to ACS for inviting me to be a part of this fantastic event. I'm excited about the entire series of interprogressive debates that ACS is putting on, and I'm particularly honored to be here at the first of them. I am also very glad to be here because, as Praveen mentioned, the issues of federalism have been important both to progressives today and have really been contested since the beginning of our nation's history, although if you listen to Tea Party history, you wouldn't know that. You think it was sort of all states, all the time from the beginning. So to put a little background to this, we started our experiment with decentralized government back with the Articles of Confederation, which were adopted by the Second Continental Congress in 1777 and ratified in 1781. Now this was real decentralized government. It was Articles of Confederation made our union built solely on a sort of league of friendship among independent states. But the national government, to the extent there was one under the Articles of Confederation, was so dysfunctional and ineffective that George Washington once said it nearly cost us victory in the Revolutionary War. So when the framers of our country came together to draft our enduring Constitution, they made sure that they wouldn't make the same mistake twice, and they created a central government that had sufficient power to act effectively in the interests of the Union. Of course, the framers of our Constitution did place much faith, not to mention reserved power, with the states. As Madison explained in the Federalist Papers, the framers thought that our federalist system and dual sovereignty among the state and federal government would prevent federal tyranny and provide, as he said, a double security for the liberty of American citizens. Of course, allowing for state variation did not always provide a double security for the freedom of all Americans. And what I would argue was the most significant shift in our constitutional system of federalism after the Civil War, we the people amended the Constitution to place key fundamental rights above the whims of local majorities in the states and localities, including, of course, abolishing slavery in the 13th Amendment, establishing citizenship at birth in the 14th Amendment, which for the first time really placed national citizenship above state citizenship, and of course protecting the equality and due process rights, including those rights articulated in the Bill of Rights against state infringement. Throughout history, over our progressive march of history of the Constitution, we the people also amended the Constitution to place other rights above popular votes or policy variations in the states, most notably voting rights, rights for people of color, women, the poor, and the young. And in all of these instances, it's important to note that Congress was empowered through enforcement provisions in these amendments to protect constitutional rights when threatened by the states and to act when states did not sufficiently protect their citizens. Today, we, particularly as progressives, are faced with new aspects of the benefits and perhaps detractions of federalism, as mentioned. We've seen mixed results on marriage equality. We have seen states being great leaders. For example, California has been a leader in protecting against climate change, and particularly during the Bush years when the EPA was, shall we say, less than active on these matters. We've also had both good and bad signs from a progressive policy preference standpoint on immigration. States like Alabama and Arizona passing show us your papers laws, while cities like San Francisco enact sanctuary laws. In healthcare, we also have some innovation in the states and localities. San Francisco, again, was one of the first government organizations to have mandated insurance in their city. So we have a lot of issues to talk about as progressives, and I'm very pleased that we have two wonderful scholars to help us sort them out. As Praveen noted, you have the bio sheet in front of you, so I will just mention a very brief bio for each of these distinguished scholars, because I could go on forever and ever. So first, I would like to introduce Professor Edward Rubin, who is Professor of Law and Political Science at Vanderbilt University Law School, where he specializes in administrative law, constitutional law, and legal theory. Professor Rubin joined Vanderbilt as dean, serving a 4-year term that concluded in 2009, and he previously taught at the University of Pennsylvania Law School and Boalt Hall at UC Berkeley. Professor Rubin has local government experience, relevant to today's discussion, having worked as a curriculum planner for the New York City Board of Education. So welcome, Professor Rubin. Thank you so much for being with us. Next, we have Professor Richard Thompson Ford, who is the George E. Osborne Professor of Law at Stanford Law School and an expert on civil rights and anti-discrimination law. Before joining the Stanford Law faculty in 1994, Professor Ford was a Reginald F. Lewis Fellow at Harvard Law School, a litigation associate with Morrison & Foerster, and a housing policy consultant for the city of Cambridge, Massachusetts. Like Professor Rubin, he also has local government experience. In addition to being the consultant for the city of Cambridge, he has also been a commissioner of the San Francisco Housing Authority. So thank you so much, Professor Ford, for being with us. So just to give you a brief overview of how our conversation will go today, we'll first hear from Professor Rubin and then Professor Ford, and both scholars will have a chance to respond to one another, and then we'll have just a conversation after that, eventually opening it up to questions. So I'm sure as you listen to what each of these gentlemen have to say, your ears will perk up and keep those questions in mind. So without further ado, Professor Rubin.
Thank you all for inviting me. I'm a big fan of the ACS. I think it's doing wonderful work, and I'm really pleased to be here as a guest of the organization. Let me start off by making a basic distinction that I make in the book I wrote about federalism. And that is because I think that that's really crucial to thinking through the contours of the issue. And that is the distinction between decentralization, which Elizabeth mentioned, and federalism. Decentralization refers to a management approach where the authority that's located in an organization is placed or delegated to regional, that is to say, geographically defined subunits of that organization. That's a strategy that virtually every large geographically dispersed organization engages in. And it's one that is used in every single country in the world. I used to say every single country except Luxembourg, or every single country larger than Luxembourg. And then it occurred to me, in the interest of accuracy, to look up Luxembourg on Wikipedia. It turns out Luxembourg has 3 levels of government, regional government and local government. So I switched to Liechtenstein, which is about the size of the District of Columbia and has fewer people than Adams Morgan. And then I looked up Wikipedia, and Liechtenstein also has subunits. So I think now I have to say the Vatican. But every country is organized that way. And you can see why, because there are many management reasons why decisions shouldn't necessarily be made by the central authority. Variations between regions, diseconomies of scale, communication problems, and the desire for local democracy to have people voting in smaller units and setting policy that controls that unit. But that's a management approach. It's something that most large corporations do as well. It is not federalism. Otherwise, every country in the world would do federalism, and we wouldn't be able to make a distinction. Federalism involves the grant of rights, of enforceable rights, to geographically defined subunits, such that they can oppose and resist an initiative from the central government. Most of the rationales given for federalism by supposed proponents of it are really rationales for decentralization. So when Justice O'Connor, for example, in Gregory against Ashcroft says, well, government will be closer to the people. It's a decentralization argument. And it's true. Government being close to the people is a result of decentralization. But of course, that's a national policy. You want a certain set of decisions to be made throughout the country by a democratic process that is closer to the people. Now, if, for example, we had true federalism on that issue, then each section would have rights by which they could oppose initiatives from the central government. then one area, let's say one state, might decide it wanted to be an autocracy, to have no democracy at all. That wouldn't serve the purpose. When we generally talk about federalism, we mean decentralization. In fact, the question is, why would any country, thinking now of the nation as a decision-making unit, why would any country want federalism? Sure, there are lots of reasons to want decentralization. Why would you want federalism? Why would the nation, the central government, disable itself from affecting a region by granting that region enforceable rights, states' rights in our terminology, against itself? Rights that, in our system, would be enforced through by the courts. Well, the main reason would be, and this goes back to Elizabeth's example of the Articles of Confederation, that that's the only terms in which you can unite the country. And that depends on what people's political identity is. If people's political identity is affiliated with the nation, then all you need is decentralization. And there'll be a nationwide decision-making process that will work, that will determine how much decentralization you have. But if people primarily identify with not with the nation, but with their own region, then they will want enforceable rights, because their desire for local autonomy won't depend on some management theory of whether it's good to have decisions being made in one level or another, or whether it's good to have variation from one area to another, but the fact that they want the decision to be made by their kind of people, and their kind of people are the people in the region rather than the nation as a whole. So, for example, that's what you have in Spain. Spain could be a national country as long as it was a dictatorship. But if you want a democracy in Spain, you're going to have to give autonomy rights to the Basque country, to Catalonia, maybe to one or two other areas, because people's basic political identity is as Basques or as Catalonians, more than as Spaniards. We saw Canada become a federal country because of the split between the French and English-speaking population. And you see that in various other places in the world, that federalism, as opposed to decentralization, is a device you use where you have divided political loyalties and separations of political identity. Now, you know, Elizabeth mentioned, when the country started under the Articles of Confederation, there had never been any unified regime. British imperial policy treated the 13 colonies as 13 separate colonies, and there was never any unified administration in North America. It was only back in London that there was, you know, that the 13 colonies were grouped as any kind of entity. And so people's political identities was with the states. And one of the issues that was openly discussed during the Federal Constitutional Convention was, will we be able to build a national political identity? And it took a while, the Civil War intervened, but after the Civil War and after the Civil War amendment, that's basically what we've done. So I think what's happened now is that federalism is basically an excuse. And it's an excuse that, as Praveen mentioned, I think has been used for the most part for anti-progressive reasons. Now, of course, it's tempting when you have something like the Bush administration to say, okay, let's all become federalists now. I think in the long run, though, it will disserve progressive interests. That is to say that the national decision-making process is the one that we should rely on to validate rights and keep moving forward. That isn't to say we shouldn't decentralize as a management theory. There are many reasons to do that. But to grant enforceable rights to states, I think, is a source of trouble, and it's a kind of trouble we don't need to buy into anymore, because we have a unified political identity.
Thank you. Professor Ford? Oh, and I would just like to say that I'm looking at my phone, not because I'm checking Facebook or anything. I'm just keeping track.
Okay, so thanks so much, and thank you for your comments. It's very interesting, and as soon as you started, I thought, I have a problem, because it turns out most of my arguments are going to be for decentralization and not federalism. In fact, I'll say right off the bat that the idea of states' rights, the idea of enforceable rights to resist national initiative, strikes me as a pernicious idea and one that we should oppose. So we're in agreement about that. I would say that there is value in thinking of some structure of decentralized authority that's a bit stronger than a management priority of national government. And so this maybe we'll have some disagreement, but not rights, but something stronger than the management priority of national government, which presumably then could be revoked at any time by any Congress or presidential administration and for any reason. To give a specific instance of the type of distinction I'm most interested in, I would not support the idea that the state could resist the imposition of federal law under the Supremacy Clause. That the state could resist having federal law apply within its borders as a state. But I would be willing to entertain the idea that, and in fact I think it's worth taking very seriously, the idea that a state or local government might have the power of initiative to initiate a variety of policies that the federal government might not want. So here we have a question of preemption, and a lot of the concern would involve the extent to which federal law can preempt state and local law, and as in the legal parlance, occupy the field, such that the state and local government can't act within that domain. Preemption is always a possibility, and the domain of autonomy that I would advocate carving out would involve the ability to resist, at least in some cases, the preemption of state and local law by federal initiatives. Now, there are two. One question has to do with whether or not, on balance, progressive policies would be furthered by having some form of stronger decentralization than we currently have. And I think there's an argument that it would. Certainly there's a long story that it wouldn't, and the story that I grew up with, that probably most of you grew up with, was the story of states' rights as the bastion of Southern racial bigotry to resist the civil rights movement. That's the story that makes it fairly compelling that we don't want anything that looks like states' rights, but also may lead people to take the further step and say, we don't want anything like decentralized authority to initiate either. And certainly we can all point to examples of state initiatives that we would oppose on normative grounds. I will quickly point to some of the state initiatives that we would probably, and local initiatives, that we would support on as progressive things like strong environmental regulations in California, gay rights ordinances, and stronger protection for same-sex couples in various states that where we wouldn't see that at the national level. States coming around to the position that the war on drugs has been a catastrophic and expensive failure with many dire racially discriminatory implications, and that's also happening at the state level because it's closer to the problem and people can see some of those implications, and also for budgetary reasons. Healthcare initiatives, and I am from San Francisco, so it turns out it's interesting that many of the examples that you cite involve San Francisco. Now, a couple of questions here. One is, I kind of blurred state and local and the city together, which someone might want to cry foul about. Wait a minute, federalism applies to states, not cities. It's states that have, but now we're, under the current constitutional structure, cities can assert their autonomy only through states. That's the legal structure that we've got. So there's just a practical question about whether or not that legal structure, with its faults, is still worth exploiting and worth pursuing, worth preserving, because it allows for local initiative, which is actually what I really care about. I'm a professor of local government law, and I think it's cities that are really the more interesting in engines of innovation. Cities are the places where democracy is close to the people. Cities are the places where people really identify, perhaps in some cases even more than the nation state. Not states, which are really somewhat arbitrary, and many of which it's hard to find an excuse for. It's not at all obvious to me why the state of Delaware should be a haven for corporations. If it were, I wouldn't oppose abolishing the state, actually, and having it annexed by some neighboring state. I wouldn't find that to be a big tragedy. So it's not states' rights, but local initiative, yes. Now, there are a few No insult, by the way, to anyone from Delaware. Just an example. There are additional questions about what we may mean by decentralized versus centralized in the context of cities. So the rise of global cities, in Saskia Sassen's terms, suggests that empowering at the local level may also be a way of furthering greater centralized coordination. That the coordination between London, San Francisco, New York, Beijing might create, in some sense, a broader and almost global type of coordination, such in ways that national policy would oppose. The distinction between rural and urban becomes important here. So these all suggest the need for a very different structure than the one that the Constitution currently sets up. And that's why I agree that federalism, in the traditional sense of the term, is something that I'm not excited about. And the underlying questions are what we can do to promote a more robust form of decentralization. Now, it is true, of course, that any more robust form of decentralization would require us to accept that there'll be some versions of it that we don't like. That there'll be some cities that initiate things that we think are bad, like draconian immigration laws that I can go on with other examples. But this is something that, of course, we would have to accept. And so this brings me to the point I'd like to wrap up with. I don't think that the question as to whether we would support decentralization in some form or not can hinge entirely on an empirical hunch about whether we're likely to get more progressive policies out of it. That we could have that discussion and try to figure out whether we think, on balance, in the long haul, the nation's becoming more progressive than the states and what have you. I think that would be a really hard thing to do. There's lots of contradictory evidence. And, of course, it would depend on whether you imagine yourself living in Arizona or Mississippi, or whether you imagine yourself living in California or Massachusetts. But, and so instead of that, although I do want to point out that there are lots of progressive things going on at the local and state level, I want to ask whether there are good meta-level reasons, or maybe principled reasons for wanting some form of additional decentralized authority. And there I think we can make a case. And the case would involve things like local and decentralized initiatives are a laboratory for democracy, meaning we try out a variety of different interesting policies at the state and local level and see how they work. One, they may not be one size fits all. It could be that what works well in San Francisco doesn't work well in Washington, D.C. But it also may be that one size would fit all, and we can find out whether it fits or it doesn't fit by seeing what happens in a particular locality. We don't have to try the experiment nationwide first. So the costs of failure are lower. There's an argument. There's also an argument about local government being a school for democracy. When one works at local government, particularly in civically engaged towns, it's a place where people can participate more directly in the democratic process than they could in national level politics. And it teaches them how to be good citizens, for lack of a better word. I think that the idea of democracy as a school, or local government as a school for democracy may have first been articulated by John Stuart Mill, but it applies very well today in some contexts. And then finally, there is the question of regional variation. And the fact that people do tend to converge on localities and regions where people of like minds are already present. And there may be reasons to think that local cultures can and ought to be given some deference, so that one social scientist, I'm going to block on the name, has described the process of the movement of Americans as the great sort. And the idea is that various regions and localities are getting more and more ideologically polarized over time, that you're going to find more liberals in San Francisco today than you would have in the 1960s. You're going to find more conservatives in certain other parts of the country. Similarly, linguists have found that even regional accents are actually diverging and becoming more distinctive over time rather than less, although everything about media theory would predict that they become less distinctive, that we have more people sounding like Peter Jennings, even though he's Canadian, and because of national media. But in fact, they're finding that regional accents are becoming more distinct because people identify with the region. The Bostonians identify with Boston, and they've over time developed stronger Boston accents, not weaker ones. And that may suggest that in the service of democracy, in the service of social harmony, and it would be good to allow for some significant extent of regional variation, even though, and in fact, perhaps because, we won't agree with what's happening in the neighboring jurisdiction. So those are a brief set of arguments in favor of some form of decentralization, although not states' rights. Thanks.
Thank you. Professor Rubin, comments?
Yeah, well, I'll have to stop nodding at things Richard's saying. I'm speaking on my own, although, what he says about environmental policy, about gay marriage, about drug policy, about the importance of cities, I'll even associate myself with the abolition of Delaware. I do want to pick up on one point he mentioned, though, and that is there a directionality to centralized or national government as opposed to states' rights on progressive issues? And I think there is. I think if you look at the country over time, you see a movement in a particular direction, not because it's inherent or given by God or anything like that, but because of the operation of the nature of principles. This country was founded on principles. It used to be thought that the American Revolution was non-ideological, and that was as opposed to the French Revolution or the Russian Revolution, its saving grace. And then, of course, the work of Bernard Bailyn and Gordon Wood and other people pointed out that there was a very strong ideology here and a clear articulation of principles in the late 18th century, principles of equality, principles of liberty, and, of course, principles of strong national government that lay behind the Constitution. Now, I think one of the interesting things about principles is you can sort of have two perspectives on it. One is the principle is stated at the outset and its substance remains what it was when you stated it originally. I think that's the originalist or the conservative position. I think it's basically a complete misunderstanding of what it means to have a principle. What a principle means, it seems to me, is a commitment to an idea that reveals itself to you over time as new experiences and new insights come to you. So I don't think anybody in 1789 had the conscious thought in their mind that when they committed the country to liberty and equality, they meant gay marriage. But over time, particularly after Stonewall, the realization has come to us with respect to that issue, as it came earlier with respect to racial equality, and then with respect to women's rights, that was really what we meant. That was really implicit in the principle, was that is an aspect of equality. It just wasn't an aspect of equality that people were prepared to conceptualize or grapple with when they first stated it. But that's the nature of a principle, just like if you commit yourself to some just ordinary principle. I'm going to get better grades in college than I did in high school. You may think that means I'm going to pay more attention in class. You may not realize, well, that means I'm going to have to give up a lot of my social life. But that's what it means to have a principle, is that you have to, confront the realities of what that principle means and make, hard decisions. And that seems to me what's happening over time. The country, sure, we have movement back and forth and oscillation, but I think ultimately that's where the country is headed, and that's why it seems to me we want basic normative decisions made at the national level. So just to finish up on the point of whether or not it's strategically valuable for progressives to rely on federalism, my answer would be no, because federalism involves states' rights. It seems to me that where we should, what a progressive position is that you support the states when they are right. That is to say, when the states out in front in the development of these principles that we've committed ourselves to nationally. When certain states are the ones who first recognize, for example, that equality and liberty mean that we give the same marriage rights to gay people as we give to straight people, or going back, or we give the same voting rights to women as we give to men, or going forward, perhaps, that we recognize that everyone has a basic right to a minimally decent life, involving health and housing and physical subsistence. So it seems to me that that's where I would want to put the forces with our developing and principled national process.
Now again, I don't find a lot to disagree with, but I will focus on one. I have a question, which is, I'm still not sure why we would associate the principles of equality, liberty, etc., exclusively with the national government rather than with the local and state governments that make up the national government, since it's really the national politics is just an aggregation of state and local politics. Tip O'Neill said all politics are local. And that's what he meant. And then you just have the question of all of the variation and what to do about it. Now, so it seems to me entirely contingent on the vicissitudes of national politics as to whether the national government is going to continue to move in a progressive direction or not. The principles, as we would like to understand them, may seem self-evident, but the problem with principles stated at the level of abstraction of something like equality or liberty is that they're quite malleable, and they sometimes actually do mean different things to different people. And so we'll also get the constitutional principle that equality and freedom of religion means that religious owners of pharmacies can refuse to administer birth control or can refuse to pay for, through the imposition of health care, the funding for abortions or what have you. That'll seem like a principled position to a lot of people, depending, so it's just going to depend on who's in power. The lesson of the years of the Bush administration, the long winter of the Bush administration, at least for me, was that it depends on who's in power, is that these people are pretty good at coming up with an argument that the principles meant the opposite of what I thought they meant. Or equality means that you can't have racial remedies for past discrimination rather than what we thought it meant in Brown versus Board of Education. And then you've also got the question of the courts. And do you know who's on that court? And you look at who, then I'm worried that the Supreme Court is not going to be the protector of our liberties and equality. In fact, we've got 5 votes at least for positions I don't want. And I'd rather have California. Or the Ninth Circuit, even with all of the problems of California. And so that's the worry, that the principles are manipulable. It boils down to politics in the end. Even the court is just politics lagged by 20 years because the justices can stay 20 years longer. So it looks like the courts will always be liberal because we had liberals in the 50s and 60s who appointed the judges, and then we had actually, guess what? In the 80s and 90s we had a lot of conservatives, and so we're going to be stuck with them for another 20 or 30 years. And so in that, I have my concerns, which brings me back to the question of whether there's a way to, yes, ensure that we have the national coordination, the economies of scale, the application of appropriate national norms, but also room for local variation, and in some sense, the ability to resist, at least to the extent of advancing initiatives that the national government may not want at times, so that the threat of a good example, as you put it, will be available. So that if healthcare works in San Francisco, rather than bankrupts the city and all the businesses, that we'll be able to have that as an example, even if the next administration decides to scuttle national healthcare, or what have you.
Thank you. Well, this was a fascinating discussion, and I'm so pleased that I get to ask questions first. It's such a wonderful moderator's prerogative. So I wanted to pick up on both of your mentions of liberty as one of our guiding principles. last term, the Supreme Court unanimously, in an opinion written by Justice Kennedy in the Bond case, held that an individual may challenge a federal statute on the grounds that it violates states' rights, that it violates constitutional powers that are reserved to the states and not granted to the federal government under the Constitution. In so holding, the court said that federalism has more than one dynamic. In other words, that federalism's limitations are not solely a matter of rights belonging to the states, but that in a proper case, an individual may challenge a federal law as enacted in contravention of federalism because, in the court's view, states' rights are very similar to individual rights, and that an individual has an interest in our federal system in the same way that an individual has an interest in separation of powers and can sue to enforce separation of powers principles. So given that neither of you seem very keen on ascribing rights to the states at all, how do you feel about Justice Kennedy's individual liberty depiction of what states' rights means? And if you don't agree with it, which I'm guessing you probably don't, how do you feel about the fact that apparently the entire Supreme Court would disagree with you?
I take it as a point of pride to be in disagreement with the Supreme Court. So that doesn't dissuade me, but though it wouldn't make me a very good advocate, I suppose, of these issues. This is exactly the kind of pernicious states' rights idea that I mentioned. I think this is a very bad idea. It doesn't make sense as a way of going about organizing government. It doesn't make sense as a way of empowering decentralized entities in the appropriate way. It seems to me to be based on almost a quasi-religious belief in the sanctity of states for the sake of there being states that is just a bad way to go about administering the law. So I'd oppose that. Now that doesn't mean that I think that the federal government should be able to do anything it wants and preempt all local or state legislation on every issue. But it means that we need to think through what would make sense as a way, not so much of autonomy, because I think rights and autonomy are the wrong way to think about decentralization. It's not really, it's not viable to have a bunch of separate entities within a national system that are thought to be autonomous of each other when we've got national commerce and people moving and the like. But some way of preserving a space for the power of initiative, but that's not it.
But so, I guess for both of you, do you think that's because the Constitution doesn't mean what the Supreme Court has said it means with respect to federalism, where the court would place importance, if not religious devotion, to the idea of states as, defenders of liberty and as important part of our constitutional structure? So do you think that's because they got it wrong on the Constitution, or do you think the Constitution is just wrong and would change it?
I don't have anything to disagree with with what Richard said in response. So, do you want to continue?
Okay, I could say a little bit more. Do I think that the Constitution is wrong, or do I think the court is wrong in the way they interpreted the Constitution? Right. That was the basis of the discussion. I think the court was wrong. Disagreeing with the Constitution is not something I take as a point of pride. But it seems to me that an appropriate interpretation of the Constitution, which was written to be deliberately quite vague on a lot of questions that it didn't provide specifics, would require one to develop doctrine that applied the principles in a way that makes sense from a perspective of national harmony, policy, etc. And the states' rights doesn't make sense. The federalism doctrine is a mess for just this reason. And if you look at the decisions in trying to carve out a domain of states' rights, they've consistently been a mess and a disaster. If you read, I believe it was one of the dissents in National League of Cities, a famous states' rights case, you'll get a litany of all the ways in which trying to carve out a domain of state autonomy cannot work. It's been tried throughout the 20th century, and every time the distinctions break down in some very, very fundamental way. So National League of Cities involved the question as to whether a federal minimum wage law would apply to state employees. Now, is that, and the court in National League of Cities said it can't apply because that would be regulating the states qua states. And 8 years later, the court had to reverse itself when they realized that trying to figure out what that would mean and when national legislation would apply to state employees and when it wouldn't was an unworkable idea. So I would say that this suggests that that approach to the question is unworkable. What we've got to think about is, and here I think Ed is absolutely right. Think about how you're going to manage the distribution of authority in a way that preserves some domain of initiative for decentralized entities, but not begin with a reified idea of the state and then say that we're protecting it from the national government. That's a failure.
Yeah, I mean, I agree completely. Remember, that, the notion of federalism that goes to the bond case is that we're getting the courts involved in making these decisions about governance. And it seems to me that that's the wrong place to get the courts involved. I mean, this is the old legal process point, that the states don't really need protection. Individuals need protection. And the bond case sort of merges those two, but merges them in the wrong way. I mean, individuals need protection on individual rights issues, not to assert the autonomy of states. And, it's not only that states are able to protect themselves. I mean, even that, I think, sort of misunderstands the case because it regards it as this struggle between the national government and the state. If you look at the average administrative program, where there's no question of federal authority, the Clean Air Act, or the Clean Water Act, or the Occupational Safety and Health Act, under the Commerce Clause, they all involve cooperation of the state and federal government for many of the reasons that Richard was talking about. And in fact, sometimes they're able to reach down to cooperation with the cities, which I agree is very often a much more important locus of localism than is the state government. But on their own and voluntarily, they're engaging in this process because it makes sense, because it's decentralized, because the states are governments in place, because you get a kind of a recruitment of local politicians, because, as Richard mentioned, very often that's the area where people can participate more readily and sort of go to school in democracy. There are all very many reasons, and those reasons are reflected in the fact that federal legislation typically is what's called cooperative federalism, although I would describe it as creative decentralization.
What do you both do then with the 10th Amendment, which says that the powers not granted to the federal government are reserved to the states or to the people? It seems that however difficult it might be to carve out a domain for the states, that appears to be what the Constitution requires. So do you think that there's any residual sovereignty in the states as a result of our Constitution's structure of enumerated powers and what most people would call federalism? And if so, how do you describe that residual sovereignty?
Well, I think that, that was such a vague formulation that you can make anything you want out of it. The question is...
But it does seem to presuppose a role for the state.
Well, yes. And I think the point is, going back to what you made, the point you made earlier, when the national Constitution was written, no one knew how this was going to play out. I mean, I think there was a principle, and in fact, as you mentioned, the primary force behind this, we need a strong national government. But how strong that was and what role it was going to play, I think was something that people just didn't know at the time. And it's something that our historical experience has revealed to us. In this case, as a result of our greatest constitutional crisis, the Civil War, we required a major amendment Constitution, my view would be that the Civil War amendments amend that, and amend that to say that we are now committed to a national regime, and that the process, because if you look at the so-called Federalist period between the adoption of the Constitution and the Civil War, I think what you see is that issue was the issue that was probably at the forefront of national debate, not only with respect to what ultimately became the cause of the Civil War, namely the division between slave and free states, but a number of other issues too. The nullification crisis of the Jackson administration had nothing to do with slavery. It had to do with tariffs and with the national government's role, economic role, and there were other issues. The New England states almost seceded over the War of 1812. So that issue was being fought over, and was the issue that was going to determine the shape of the country. And there were two trends. One trend was toward greater and greater national integration and national identity on every other issue, and greater regionalism on the slavery issue, where there was where the conflict became more and more intense as the abolitionist movement progressed in the North, and slavery sort of hardened into an economic system in the South. And I think after the Civil War, we got our answer, which is that we were going to have a national regime.
So no residual sovereignty in the states?
No, it's just a matter of how our political system works out. But I don't think we need to identify the states as having rights, which means we don't need to invoke judicial protection for them.
That sounds right to me. I would say, okay, I was kidding about Delaware. Congress can't abolish Delaware. It independent means that. There's a question about whether we're saying what do I think we should do and what do I think constitutional law says we should do. What I think we should do is repeal the 10th Amendment, but what the constitutional law says is somewhat different. So we can't abolish Delaware, but and I would say, both as a matter of constitutional law and what I think, that the residual sovereignty means some power of initiative. It means that Congress can't pass comprehensive legislation that preempts everything that the state might want to do on every issue. I think that a lot of the tension would involve preemption of state law, that's where the fight should be, about when the federal government can preempt state law and occupy the field. But what hasn't been workable, now after Garcia, which was the case that came after National League of Cities that I mentioned, when the court went back and said, okay, we give up on this idea of carving out a zone of autonomy for the states qua states, the court said, the states are protected by the process. That the Congress is made up of representatives from states, and so that's sufficient to protect the states. Now that's kind of a weak answer, because you wouldn't say, for instance, well, the individuals are protected by the process because Congress is made up of individuals. So from a states' rights perspective, it's not a really great answer, but it's better than the alternatives, which we've seen. So after that, we got an attempt to carve out various things that the Congress can't do, like commandeering. So we had cases where the Congress may not commandeer state officials and make them enforce federal policy. You can have federal policy, it applies in the states, but you can't make the state and local officials enforce it. You have to send in federal marshals to enforce it. This seems like a silly distinction to me, and one that wasn't very well defended in the case. So that we're trying to do things like that because even the stronger advocates of states' rights on the courts are not willing to say that we're actually going to prevent the application of federal law in any substantive way. So we're coming up with these kind of little things, and it just hasn't been a workable project. We've got to come up with something different. It seems a shift in focus, and you're focusing on what I think really matters, the organizational questions, the virtues of decentralized authority, and what's necessary in order to make that a viable system. That's where the action ought to be, and that's what I would want to see read into the 10th Amendment, although I would admit that it's not written in such a way as to make that the obvious approach.
So if we have questions from the audience.
If you could wait till the mic gets to you and just identify your name and affiliation, that would be fantastic. In terms of predicting whether the nation as a whether the nation is going to trend more liberal or local entities are, you have to take into consideration, you have to put together the big sword with our Constitution, which gives small states, individuals in small states, incredibly more political power than individuals in large states. So if to the extent that the conservatives consolidate in small states, they're going to run everything. And the other thing is if after Citizens United, it's going to matter in either case. I mean, corporations can buy city councils as well as they can buy Congress.
Great question.
Yeah, well, I think you're right. Sandy Levinson has made this point that a number of our systems of representation are artifacts of the previous state-centered system, specifically, as you mentioned, the allocation of electoral college votes and the voting in the Senate.
Right.
And his point is that those are just openly anti-democratic. So I think that's right. That's clearly a result of the earlier organization of the government when it was being formed from essentially 13 independent entities. And I think the fact that when we look at that, apart from whatever kind of quasi-religious attitude we have towards states, I think its anti-democratic nature is apparent to us for just that reason.
I agree. I think it was Slate Magazine had a series called America's Worst College, which was about the Electoral College. There's an additional perversity to what you're describing, which is, at least from my perspective, to the extent that the concentration of people in cities expresses a lot of the dynamism of the country, and also expresses the potential for these kinds of global connections that I was describing earlier. What you have is a state of affairs in which the people in the least concentrated regions, which are least representative and least likely to be confronting the most important issues facing the nation, have a disproportionate amount of control rather than the reverse. Or rather than at least, at the very least, a straightforward democratic one-person, one-vote system. So that's a real, it's a real perversion, and I mean, maybe it's time for the Constitutional Convention to fix this problem.
Can I just follow up on that? Because I think it's a really important point. I mean, if you're concerned about balance and fairness, the most important thing, it seems to me, in the country now isn't state versus state, but really urban versus rural. I mean, that's where the difference lies. If you look at the county-by-county map of the, let's say, 2008 election, what you see is large areas of red and little dots of blue. The large areas of red are the rural areas, and the dots of blue are the urban areas, and that's true in virtually every state, but the state went red or blue. What was interesting, if you look last night at CNN when they were doing the Ohio election, they reversed the colors because they were showing Santorum in blue and Romney in red. But it was the exact same thing. Romney, not exactly a liberal, but liberal compared to Santorum, had the dots of red in this case on a diagonal going across Ohio where the cities were, and Santorum was carrying all those small rural counties. So that distinction is one that's very deep and is, I think, a national phenomenon. It's true in virtually every state. It just changes the balance. And so to overrepresent rural areas is really anti-progressive. And in addition, it's unfair. If you were going, and I agree with Richard, if you were going to weight the representation in any direction, you would want to weight it in terms of the more dynamic, more economically important, more global areas of the country, and those, of course, would be the cities.
So it seems like that discussion kind of brings back the point that was being made earlier, kind of half-jokingly, about the states being, to a certain extent, irrelevant for both of you, and and I don't know that I agree with the idea that the city should be more important than the rural areas, but that the local layer should be most important. So I was just wondering if either of you had any thoughts on ways that could actually happen, or what that might actually look like for the states to lose importance and for the local areas to gain power, or power of initiative, or whatever it is. Oh, sorry, Becky with the Food and Drug Administration.
Well, yeah, okay, the short answer is you need several constitutional amendments. But barring that, there is some reason to think that the federal government's relationship to the city might be a mechanism for accomplishing this. So, now, as things stand now, typically the city has to act through the state. The city's understood as exercising state power that's delegated to it, and the state is in control of what happens with the cities. That's formal law. It's all a matter of state law. But there are interesting exceptions where the federal government has actually reached down to the city and has successfully, against the will of the state, dealt directly with local government, and successfully. One case I'm thinking about in particular involves something called the Payment in Lieu of Taxes Act. But it was basically a federal act that, in localities where there was a lot of federal property, like a park, they would give, and so it was a tax-exempt land. The Congress would give payment in lieu of the taxes that the local government would have collected if it hadn't been tax-exempt. And then the question was whether the state could come in and say, no, we get to decide how that revenue is distributed, because it's actually state revenue, as opposed to local revenue. It's all state revenue. Or whether the locality gets to decide. And the court actually held that the locality could decide, that Congress could reach and give money directly to the locality, and because it was Congress's money, and say the locality decides how to spend the money, not the state. So that's an interesting example where may really be centralized power serving decentralization.
Yeah. Once again, I'm having a little trouble disagreeing with Richard here. Yeah, what we need, it seems to me exactly, is a national policy that's an urban policy, and that deals directly with cities and deals directly with city issues. We need mass transit, we need housing policies, we need a whole set of policies that are relevant to urban settings and urban problems, which is increasingly not only where a larger and larger proportion of the people live, but where so much of our economic dynamism and our international role lies. One problem that I think would require a constitutional amendment is it's fine to have states. We just need to redraw those state lines. I mean, clearly, the big metropolitan areas should be their own states. That is to say, as a totality, they should have an integrated government, and that government should have a direct relationship with the federal government. There are very few, except for, things like Switzerland. But when there aren't historical impediments of federalism, there are very few countries where the biggest cities aren't also the most important regional divisions. New York and Chicago and Los Angeles should be our three biggest, most populous states, because they are the most important entities, it seems to be, below the federal level.
Article 4 of the Constitution, you can change the borders of a state. And to stand up for Delaware, you cannot annex a state without the consent of the legislatures of both states and Congress. So I suppose you could change the borders if both states and Congress were amenable, but you can't just get rid of Delaware.
Alas.
Thank you. David Sobelson. You've found so little to disagree about, I'm having a little difficulty figuring out how this is a debate. You both seem to agree with the theory first set forth by Herbert Wechsler in his 1961 article, The Political Safeguards of Federalism. I have a somewhat different question for you, which you really haven't touched on, and that is, would you support judicial abandonment of the doctrine of constitutional preemption, so that for the Supremacy Clause to work, Congress or the President would have to have acted in some way to make clear the federal government's disapproval of the state action, and the courts could not throw out state action because it was implicitly in conflict with the power of Congress under the Constitution.
Which is Justice Thomas's position, what you just articulated.
Oh, gee, the short answer is no, I wouldn't support that. Well, I think for now I'm just going to leave it there. That would not be my position.
Well, just to follow up, because again, you're not, unfortunately, get a lot of disagreement, I guess, between us. But, you know, the question is the intent of Congress. And it's not always clear that, as I mentioned, that Congress wants to preempt state law. I mean, Congress very often chooses on its own to not only leave the states in charge, but to support their authority or to rely on their authority in governance. And that's because it makes sense as a management matter to rely on states in a whole variety of areas. So preemption questions are basically questions of constitutional intent. And you have to decide what Congress intended. But if the courts are reading constitutional, the intent of Congress, it's possible to overread it.
Yeah, now I can say a little bit more things about this. The tricky question of all of these, what can we imply by silence, and what do we think about the legislative process? The idea that Congress has to be explicit relies on, it seems to me, a notion of the legislative process that's wrong or that's naive. It's that Congress will speak with one voice when it passes legislation, and it could be clear if it wanted to. But what you really have is a kind of we all know what the actual process is like. If you don't like large sausages, don't look at how they're made. And so you get something where we've got to figure out what Congress was trying to do. And sometimes Congress punts the question to the courts. Justice Stevens mentioned this in an interesting interview in the New Yorker, but he said, at one point I was a legislative aide, and there was a question that was ambiguous, and I said, to the Congress person I was working with, what are we going to do about this? We need to make this clear. And he said, I think we'll just punt that one to the courts. And so what Congress intends is to punt the question to the courts sometimes, with the understanding that it's going to do something that's sensible, all things considered, given the questions that we didn't know about when we wrote the legislation. So I wouldn't be in favor of a rule that says Congress always has to be explicit. I think we're really stuck with the problem of interpretation. It's just most of what courts do.
But that's not particularly democratic.
Not particularly democratic.
To punt it to the courts to...
Well, I'm not sure about that. I mean, it's an interesting question of what we mean by democracy. Congress, the democratically elected people in Congress decided to punt the question to the courts because they couldn't agree, but they wanted legislation. That's what they intended. That seems to me consistent with democracy. The courts have a role to play in applying the law. Congress can't apply it in specific instances, and part of the application is dealing with ambiguities that arise that weren't foreseen, or in some cases were foreseen and, punted.
Yeah, I have to agree completely. I mean, democracy, democracy has, built into it publicly elected figures, but that doesn't mean that publicly elected figures make all the decisions, and you can't run something like that. And indeed, it's, I think, a rich notion of democracy that allows, for example, for judicial independence, where, you want the national legislature to be able to use the instrumentality of an independent judiciary to do things like resolve disputes, which we all agree about, but also then resolve certain types of uncertain questions. You can give some to agencies and some to courts, but you can't decide it all yourself, and that would essentially disable the democratic process, namely the elected officials, from accomplishing the basic policy goals they want to accomplish. It would be a burden to them, not a grant of power to them, to force them to make all the decisions that need to be made, or even all the major decisions that need to be made.
since there are good examples of where states and federal government authority can be captured by private interests, which we haven't really talked about directly here. I'm wondering if we need to go beyond the federal versus state dichotomy to talk about natural law. I'm a sociologist. I don't know if you have that concept in the American society, Constitution Society, but where we can, and not just natural law, but even human rights at a universal, global level, as ways of really promoting the objective of progressivism, which I think is the intent of this debate. How to get further, how to move both state governments and federal governments in the direction of greater progressivism. And I'm thinking that given the politics of that we're facing now, a very deregulatory environment, I'm seeing some more progressive things coming at the municipal level, ordinances based on rights that are not related to the states because they're easily captured by corporations, or the federal government, which is paralyzed the way we see. So maybe we can broaden the debate to include some notion of human rights and natural law.
I'd say in the place where one might see more of a focus on human rights is when local governments are trying to negotiate and work with other cities internationally. And so the language through which localities might work with localities in other countries might be international law and sometimes international human rights. And you certainly do see some local governments saying, we are going to, San Francisco again, we are going to adopt the International Convention on the Elimination of Discrimination Against Women, even though the United States has never ratified the convention. So, yes, there's an example, and we're going to do it because we're progressive, but maybe also we're going to do it because our strategic trading partners in other parts of the world have done it, and will see us as a more reliable ally if we signal that we share their values. So there might be some of that involved as well. And this kind of goes back to the question of the way that it's unfortunate that the entities that we consider to be sacrosanct as decentralized entities, namely states, don't correspond very well to the more organic and lived entities in which commerce and culture and day-to-day life are happening. And so we've got a system, and this is why we keep coming back to the idea of amending the Constitution, because the structure that we would need, we're talking about revamping. Right now, in order for the greater metropolitan New York area to do anything, it's got to coordinate between 3 different states, 4. And so you've got, and every once in a while you can do it, but our system doesn't make it easy. So you've got the Port Authority of New York and New Jersey. Why do we have that? Well, because the metro area includes New York and New Jersey. And so you've got to have some weird regional entity that nobody really understands. Talk about anti-democratic, people don't even know what it does. They don't know how it's empowered. They don't know who runs it. And a lot of our government is being taken over by these kinds of special purpose districts and administrative regional agencies, because you've got to do something to get things done. And you can't get them done within the structure of general purpose local governments. But people, the voter doesn't understand. If you ask, when the subways go on strike in New York and everyone says, Mayor Bloomberg better fix the subways or he's toast. And it turns out Mayor Bloomberg doesn't run the subways. They're run by an independent agency and no one understands that. So that's anti-democratic. It's a huge problem. And if you put all this together, we could start to imagine a better system. But yeah, it would require several constitutional amendments and a lot of hard work.
Yeah, and I think one of the points Richard was making is that the modern version of natural law we no longer think it's the mind of God communicating with people through rationality, is really these international understandings. It's the notion of human rights. And that's why it's important, I think, that the cities and the places that are in communication internationally. I mean, I'm not exactly sure why. I mean, I don't know quite enough about American politics. I understand your point why we're disproportionately representing rural areas at the federal level. But even after one person, one vote, it seems like a lot of states are disproportionately controlled by their rural districts. And it seems to me that that's a problem, and that, just what Richard was saying, it would make sense to free our major cities from the stranglehold of upstate or downstate regions that are acting against their interests and treat them with a certain amount of distrust.
Yes, in the back.
I would. It's so difficult to actually make any kind of general rule. What may appear to be democratic maybe maybe progressive. For example, your little reference to the Port Authority. Around here we have the Washington Metropolitan Airport Authority, which is pushing for a project labor agreement, trying to provide more money towards transit, trying to get all the localities. And so it's made up of 3 appointees from the president, 5 from the state of Virginia, 2 from Maryland, 3 from the district. And that's our progressive authority, even though no one really knows a lot about it. But my question really, and that relates to your point of this rural-urban thing, is at least in the state of Virginia, we have something called a Dillon rule, where localities can do practically nothing without the state. And it's sort of quite ironic that the Republicans are big supporters of a centralized state so that all of our money in Northern Virginia ends up somewhere else, and we can't engage in the kind of progressive politics as, for example, living wages, etc. And if you could comment on that.
Sure, Dillon's rule, there's a fascinating history of Dillon's rule, which makes it a little less surprising that conservatives are for it, because it originated in part out of a distrust of big cities. Big cities as the home of corruption, but also as the home of immigrants and in various kind of undesirable populations that people thought shouldn't have control and needed to be reined in by state government. So Dillon's rule is exactly the kind of thing that I am worried about when, in terms of strong arguments for centralization. It's the idea that the local unit can't do anything without an express grant of power from the centralized authority. And that's why I kept talking about initiative. So it's interesting that you bring up Dillon's rule. I mean, the worry would be that we wind up in a state of affairs where you can't do anything without first going to the centralized authority and asking for permission. And I wouldn't want to see that vis-a-vis the federal government. And you're right, we already have it in state government, particularly in states with a strong Dillon rule. And it's bad for cities, and I think it's bad for policy generally. That's the fear. In terms of the authorities, one thing I want to say about decentralizing power to these kind of regional authorities that are made up of a variety of representatives from different states. We need that. It's the only way to go when you've got metro areas that span state boundaries. But there are 2 questions. One is it a good thing to turn that authority over to a relatively unaccountable body based on the idea that they have expertise? And that's usually the way it's understood, where they're going to focus on a narrow thing, not general purpose, and they're experts. That might be a good idea sometimes, and it might lead to progressive outcomes, but we at least should be making a conscious decision that that's what we want to do, rather than have an entity that's democratically elected, democratically accountable in the more conventional sense. And right now, I don't think we're making that decision. We're defaulting, because you can't get anything done in a metro area that spans state boundaries without doing it that way. You can't. Under the system, it's very hard to set up a democratically elected entity that's going to cross state boundaries because of states' rights and all of this. That's the problem that we face, particularly on the East Coast. On the West Coast, it's somewhat less severe, but we still have versions of the same problem.
Yeah, Dillon's rule actually is a states' rights rule, right? Because what it means is that the states are the entities that have sovereignty, and then all the localities are defined as creatures of the state, and the federal government is supposed to respect the state boundary rather than reaching down to the city level, as Richard was mentioning.
So we have time for one more quick question, and I know the young gentleman in the back is going to hand up.
Gabriel Weil, Georgetown Climate Center. I want to ask Professor Rubin how your framework applies to climate change. It seems to me that the management theory rationale for devolving power to states really weak there. It's a global problem. No one thinks it's best solved by a fractured, state-by-state approach, but there's no political will, at least with the constraints that our system has, to do something at the federal level. And so whatever rationale you're going to have for state action is going to be political, to some extent maybe laboratories of democracy, but it's more just you don't have political will at the federal level. So how would your framework apply to that? Obviously, the federal government could preempt state climate policy if it wants to. It hasn't, but I don't think that really answers the question. If it did, would you think that power is an appropriate one under our system?
Yeah, it's a very interesting question. I mean, I mentioned these sort of foundational principles of the nation. I don't think environmentalism really was a foundational principle. I think that was something that they just weren't thinking about at all. It's sort of interesting, isn't it? I mean, you talk about global warming. Why does global warming, I mean, it's an empirical question, right? Is the climate warming up or not? Why does that question align so closely with political views about things that have absolutely no logical connection to them? I mean, authorizing gay marriage will neither contribute to nor detract from global warming. I mean, there are not two more different issues, two more separate issues in all of politics. And yet the correlation between people who believe that we should permit gay marriage and people who think that global warming is occurring is, I would guess, extremely high. And I think there's a kind of a mystery to why that is. The only thing I can think of, though, is that it really is a matter of national policy. I mean, it's great to see localities experimenting. It's great to see them dissenting from the Bush administration and saying, as California did, no, we have to take this seriously. But ultimately, it's indeed an international question. It's an international question that will have to be worked out between the existing divisions of the world, which are national. And I think what has happened is that people who believe in national policy and progress, as kind of progressive approach, have understood that global warming is an international issue that will have to be solved between nations. And the affiliation of conservatives with the opposition to it has to do with their general opposition to a active, interventionist, forward-looking government. So I think that's the reason. So, ultimately I would say that it doesn't align very well with principles, but it does somehow reverberate with the notion of having a strong national government and a strong national policy. And ultimately, it's, although it's great to see states acting as laboratories, ultimately it's going to have to be national policy and indeed international policy negotiated between nation states.
Wonderful. Well, thank you so much for all your questions, and please join me in thanking our wonderful